Welcome back to our listeners and viewers. Our final speaker on this topic of criminal defamation is Advocate Les Morison, SC. Les is a member of the ANC Legal Research Group and also a practicing advocate at the Johannesburg Bar. Les?
Thank you. Morning, thank you. I acknowledge the Minister and Advocate Lakula. It's an honor to be able to speak in your presence, and thank you, Mr. Minister, for those inspiring words. I, with respect, have been briefed to be something of a devil's advocate on the topic and to argue for a limited retention of elements of criminal defamation and to explain how our courts have come to the conclusion that it should remain part of our law and that it is in fact constitutionally sound. And at the outset, I'd like to pose this question to you because it was one of the persuasive questions that was asked by the court in the decision of Ho-Ho. And that was a very illustrious bench of the Supreme Court of Appeal with very impressive judges coming to that conclusion. And that is, if there is a civil remedy for physical assault and a civil remedy and a criminal remedy for physical assault, why shouldn't there be a civil and a criminal remedy for assaults on one's reputation? And the answer is quite clear in my submission. A criminal sanction performs a different function, and a civil remedy is available actually only to private citizens who can afford to get to lawyers. So when we look at retaining the criminal component of any aspect of our law, what we are saying, in effect, is that the police, the criminal courts, the prosecuting authority are available as a state service to protect the reputations of people who might otherwise not be able to afford to obtain any legal remedy at all. And what I'm asking is that we look to the poor people, the people without access to private lawyers. We shift the paradigm of this debate away from the press versus powerful public figures. And we ask ourselves, how would a rural person facing a whispering campaign of being involved in witchcraft or other highly malicious whispers against them that might affect their employment, that might affect their political aspirations, that might affect their opportunity to marry the person of their dreams, how do they protect themselves other than through approaching the police? There are no private lawyers practicing in the far-flung parts of our country where reputations are equally, if not more important. And if criminal defamation was removed in its entirety from our common law, it would be a free-for-all, and one would remove the very important sanction and the services of the police, the prosecuting authority that are located in those areas, and the criminal courts that are located in those areas, and send the message that it's not permissible to behave in this fashion. And so we must bear in mind that reputation, which is what defamation is about protecting, is a vital part of the right of dignity, and it enjoys fundamental protection in our Constitution. So when one speaks of defamation, one's not talking merely of journalists pointing out corrupt officials in high places. One's also talking about people who have very important rights of dignity, and our courts have emphasized again and again, as in Ho-Ho and in Motsepe, that dignity is the counterbalancing feature to freedom of expression, and courts are engaged in that balancing act all the time. And there is no widespread abuse of criminal defamation laws in our society. Our courts have been acting independently. Our courts have taken a very balanced view to it. And in the case that is the subject of this particular workshop, Motsepe, let us bear in mind that Motsepe, the journalist who took a court record, got a lawyer to translate it for him, which was a bad idea in the first place, worked off the lawyer's say-so as to what the record said, and then published a highly defamatory article about a magistrate to the effect that the magistrate was a racist, and that the magistrate used different forms of decision-making processes for one race as opposed to the other. That magistrate's reputation was severely hammered and damaged by that allegation. But Motsepe was acquitted. On appeal, he was acquitted, precisely because it's very difficult to prove that somebody is responsible for criminal defamation. He was found not to have had the intention because he'd got it wrong. He thought what he was publishing was true. He thought what he was doing was correct. He thought that the lawyer that advised him was correct. And therefore, Motsepe was acquitted. So the way our criminal defamation law works is not as onerous as in some countries where it's used to oppress journalists and limit freedom of speech. Our Ho-Ho decision is another important example where a particular official, a researcher in a government department, was publishing secret pamphlets accusing high-ranking people with very responsible jobs of sexual impropriety, of corruption, of theft, of dishonesty, of tender rigging, 22 separate counts of a campaign of secret pamphlets that would never have been exposed had it not been for the involvement of the police. And I ask you to bear in mind the role of the police in criminal defamation. They investigate. They are the first port of call for enforcing the laws of our country, and the criminal laws of our country must be made available to those who face these campaigns. To take the facts of Ho-Ho, one would picture maybe 10 different officials, all as plaintiffs, all going to see individual lawyers, all bringing separate cases to the civil courts against one individual who might be quite difficult to track down and who would be quite incapable of paying the damages awards necessary, because that's one of the other problems with civil defamation, is that even if you can afford as a defamed person to go to court to get a lawyer to represent you, the person you get the award against in a monetary fashion may not actually feel the consequence of that because they may be impecunious. So to pursue the rights of the persons who were the victims of the defamation in Ho-Ho, people entrusted with the development of our democracy, people entrusted with important public functions, in order to get those people protected in a civil remedy would have been a big, arduous, expensive case that would probably not have achieved very much, whereas a criminal defamation charge was instituted. 22 of them were instituted. And the court was required to decide whether or not at the Supreme Court of Appeal level, whether those charges on which he was convicted should stand. And let's put it bluntly, a cancer in our political structure was eliminated. That was very focused, radiation beam focused on that particular malevolent cell, and he was nailed by the criminal law of defamation in order to protect those officials who were quite wrongly defamed. So I would argue that we need to retain the criminal law of defamation, but we need to follow the lead of the African court, which is to remove the sanction of imprisonment. That's what was decided in the decision against Burkina Faso, where the gentleman that Dario spoke of was the publisher of a newspaper called The Hurricane. And he alleged that a public prosecutor was guilty of corruption. And he was found to be guilty and subjected to imprisonment for 12 years, or 12 months. And what the African Court on Human Rights decided was that he should not have been imprisoned, and it gave a direction which is binding on all African Union states to remove from its statutes books and from its laws, to the extent that it was common law, the sanction of imprisonment for criminal defamation. And I would argue that in the very welcome approach that our party wants to make to change our law of criminal defamation, that we should retain it to a limited degree, but eliminate the threat of imprisonment, because that is probably going too far, and sentences of community service, sentences of fines for appropriate defendants would be a better way of modifying our criminal defamation law, but still retain to those of our people who need access to that form of protection. Young people using cell phones, being persecuted in cell phone campaigns, who don't have access to private lawyers. Social media journalists who don't have access to private lawyers, but play an important function in keeping the exchange of ideas going in our society. Those people need to be protected by a more temperate, more humane form of criminal defamation. Thank you.
Thank you very much, Les. We're now going to go into a very interactive debate on the topic. We've had a cross-section of views expressed by our speakers, but before that, we'll take a short break. Thank you.